Because understanding great literature is better than trying to read and understand yet another business book. On the Leadership Lessons from the Great Books podcast, we commit to reading, dissecting, and analyzing the great books of the Western canon. You know, those books, from Jane Austen to Shakespeare, and everything else in between, that you might have fallen asleep trying to read in high school. We do this for our listeners, the owner, the entrepreneur, the manager, or the civic leader who doesn't have the time to read, dissect, analyze, and leverage insights from literature to execute leadership best practices in the confusing and chaotic postmodern world we all now inhabit. Welcome to the rescuing of Western civilization at the intersection of literature and leadership. Welcome to the Leadership Lessons from the Great Books podcast. Leadership Lessons from the Great Books podcast, episode number 114, with Dorollo, Nixon, the U.S. Constitution, and the 10th Amendment in leadership. In 3, 2, 1. Hello, my name is Hassan Sorrells, and this is the Leadership Lessons from the Great Books podcast, episode number 114. With our document today, continuing in our journey through the founding documents of the United States of America, the United States Constitution. The U.S. Constitution is the oldest written and codified national constitution in force in the West today. And it is a charter, to paraphrase from one of our more recent presidents, of negative rights. It's about what the government cannot do to you, rather than what the government can do for you. In the parlance of our time, the Constitution defines the relationship between the people and the state and lays out in a practical and easy to understand fashion what the duties of government actually are in a negative way. It also acts as a companion document to the Declaration of Independence, which we've covered on the previous podcast, in that it aligns the mission of the United States with the vision declared so clearly in the Declaration of Independence. To discuss this today, specifically to discuss particular amendments that are in this Constitution, we'd like to welcome back a good friend of the podcast, Dorollo Nixon Jr., Esquire. Welcome back, Dorollo.
Thank you, sir. Good to be here.
All right. So today, like I said, we're going to cover one amendment in particular. It's probably the amendment that I think is understood the least in the context of the last 100 years, particularly in light of the expansion of the administrative state and the growth of administrative and executive power, and not only in making regulations in our country, but in actually enforcing those regulations. If you've ever been hassled on your land and you live out west by a 3-letter agency known as the EPA, if you've ever had to go through a background check in order to buy a gun, courtesy of the DEA or the ATF, or if you've ever tried to open up a drug dispensary in Colorado, courtesy of, legalization of marijuana in Colorado, and you've been hassled by the IRS, you have been the victim of regulatory and administrative overreach that puts paid some of the ideas that are inside of this least understood amendment. Of course, I am talking about the 10th Amendment to the U.S. Constitution. And I'm going to quote directly, to open up here today, from the 10th Amendment to the U.S. Constitution. It's a very short amendment, and it literally, well, not literally, it says this, and I quote, Article 10, U.S. Constitution, okay, after we go through all of the other articles, and I quote, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people, close quote. Now, when we think about that idea about who has power in a nation state and what does that actually look like, and we talked a little bit about this in Lockean terms and in Tocquevillian terms on our last episode with Dorollo, focused around the Declaration of Independence, when we think about the relation of the people to the state, but we also think about the relation of the states between each other and their relation to the federal government. Well, this is where we begin to get into some challenges, and we're going to talk today about challenges to the Constitution from the Federalist Papers, or defenses of the Constitution from the Federalist Papers, as well as challenges to the Constitution and to its ratification, which led to the creation of the 10th Amendment via the Anti-Federalists, most notable of whom was a gentleman named Patrick Henry, who just wanted to be left alone. We'll also trace that kind of being left aloneism streak that runs through American culture down through three current Supreme Court decisions that have begun the process, I think anyway, of pulling apart and restructuring the nature of the administrative state in America. Loper Bright Enterprises versus Raimondo, that was this year. EPA versus West Virginia, that was last year. And Corner Post Inc. versus the Board of Governors of the Federal Reserve System, that was also this year. And we will talk about those, like I said, with Dorollo Nixon today. So let's start off with that pesky 10th Amendment. Dorollo is a constitutional lawyer, so we're going to get his thoughts on the 10th Amendment. So Dorollo, let's get a little history on this. Why is the 10th Amendment important? Why do the founding fathers believe that it was critical? And why did the Anti-Federalists insist that the 10th Amendment be included in the Constitution?
So there's a lot there. The reason that the 10th Amendment is there is because of how the conception of power existed in the minds of the framers. And I like to distinguish between the founders and the framers, because not all of the founders of our country in 1776 were involved in the framing of the Constitution in 1787 through 1789. And so in the minds of the framers, okay, the Constitution was an express delegation of certain powers only to the federal government. And one of the ways this was emphasized, okay, after the fact, was by passing the 10th Amendment, which served basically as a reminder, okay? And in fact, it goes hand in hand, in my opinion, with the 9th Amendment, okay? The 9th Amendment reads, reads that the rights enumerated in the Constitution, I want to get the actual text right. Bear with me because I have it here. I thought the screen I was reading from that showed me the text was showing me the actual text, and instead it was abbreviated, and that let me know in the middle of a sentence. I apologize. Here's how it reads. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others. Here's the key bit. Retained by the people. And then here's how the 10th Amendment reads right after it. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, comma, or to the people, period. And just as an aside, commas are really important in the law because they can be used to make the case, pun intended, that you're dealing with multiple ideas instead of one idea. So one of the things that I do when I'm drafting, certainly when I'm drafting a contract, I'm leaving out as many commas as I can. And that way, people understand that it is a series of things that go together and not separate ideas differentiated by commas. Anyway, back to my actual point. Sorry. In the eyes of the framers, in the conception of the framers of the Constitution, it was a limited grant of authority to the federal government for certain purposes only. Okay, the federal government with its three branches, right? The legislature, Congress, the executive, and this is the order of the articles in the Constitution, right? Congress first, and then the executive second, and then the judiciary third. That these were limited grants, and that as a result, there were other powers, or there was more power out there in the public sphere, as it were, okay, that was or were, depending on if you want power or powers, retained by someone, Okay, there's a limited grant from a larger fund. Well, there has to be something that remains because it was a limited grant, not a complete grant.
Yep.
Okay, and so these two amendments serve as a bookend, communicating quite clearly that in the framers' minds, if it wasn't delegated in the Constitution, nor something that was prohibited by the Constitution to the states, okay, that the powers were reserved to the states, and just to the various states, right, to the 13 states at the time, or to the people themselves. And so for those of us who are limited government fans, or partisans or patriots or whatever noun you wish to choose, that recognizes that this is how you see the framing of free government, these amendments are very important. And of course, they're little used. I can't tell you a single case that deals with them. And to me, that's not an accident. Okay. I also think it's important to remember that, and this is me, the originalist, right? That those amendments came in a certain context. Okay. They were almost immediately adopted after the Constitution itself was ratified. Okay. And so just to give comparison, the next two amendments, one became law in 1795. That's the 11th Amendment. Okay. That laid the foundation for state sovereign immunity. So we're still on the same theme. Okay. Or one of two themes, I would argue, but we're still on one of two themes, i.e., that there were powers retained by states, that the Constitution did not transfer those powers to the federal government, and therefore that the federal government had to respect state authority to do certain things. Okay, we're still on the same theme. And then the 12th Amendment that relates to the election of the president and the vice president and changing the nature of how that worked. That became law in 1804. Okay, each of those amendments significantly took less than a year to be ratified. Okay, in contrast, the Bill of Rights, which includes the 9th and 10th Amendments, took more than 2 years to be ratified. Okay, but anyway, after the 12th Amendment, there aren't any other amendments adopted until the end of the Civil War.
Right. With the 13th Amendment around slavery and the result
less
of that
than a year.
apocalyptic Civil War. Right. Okay.
Yep, in less than a year. And then the citizenship one, the 14th, took almost as long as the Bill of Rights. And then the right to vote took under a year. But yes, from December of 1865 through February of 1870, those three amendments were adopted. So the ones we're dealing with were from a different era. Okay.
Right.
The thinkers and the writers who drafted them and created them, and the men who voted on them were creatures of a different age, in my opinion. Okay. One in which government was a lot more personal, when, for example, the Senate would have had less than 30 people, less than 30 men, so they could fit in a boardroom. Okay. So think of advise and consent. It's like a board meeting, right? And now it's a circus. And so, and literally a circus, and on TV and everything is entertainment rather than,
governance.
A bunch of men in a room.
Yeah.
The most exclusive boys club on the planet you can get elected to, a bunch of men in the room, deciding who gets to be a judge and who doesn't, which treaties get ratified and which don't. It's quite impressive, but it was personal. It was their interactions. These men knew each other. Okay, they knew their foibles. They knew whom they loved and whom they hated. And so this is one. These two amendments arguably are one of two legs of our federalist system. Okay, of American federalism. Okay, if you don't have them, then the claim that government in the United States is limited in scope, limited in authority, wouldn't exist. It wouldn't be reasonable to make that conclusion. And in comparison to the rest of the world, that's too broad of a statement. In comparison with much of the rest of the world, and certainly with other types of constitutional systems, it's much harder to make the argument. I'll give specific examples in a moment. It's much harder to make the argument the government is limited. Okay, the one I know best is that the government of the United Kingdom and the supremacy of Parliament has existed effectively since 1689. Okay, 1688, 1689, with the Glorious Revolution, and then the passing of an act in 1689 that basically said it's really Parliament in charge. And so we brought the king back over the water. And we got rid of this other, we brought a king back over the water. That was the end of Cromwell. Okay. Cromwell was done. We brought a king back over the water. We did it. He didn't just show up. We invited him. We brought him back. Okay.
Correct.
And now that his brother is trying to do things we don't like, we're going to chase him away. We're going to bring some guy named William of Orange from the Netherlands. Forget about the fact that we were fighting them 2 decades before. But we're going to bring, and they did a very good job handing the British their behinds in that one. Okay. It's around 1665, 1666. Anyway, they brought him over. They put him on a throne because they wanted a Protestant on the throne. Who was unequivocally one, and then they basically said, "We run things." And so the doctrine of parliamentary supremacy is something that exists in England, in British political, in the British political system, in within the laws of England and Wales, because they're actually also two separate things. But anyway, they basically make rules with impunity. Okay, they do not have a limited government.
Right.
What they have arguably is absolute representation, and that apparently justifies the situation because you know who's making those laws, and therefore you know how to cashier them. Okay? And you also have somebody at the top who technically, despite the recent, so there's a recent Supreme Court decision, because the UK now has a Supreme Court. It used to be the House of Lords, and it was particularly, there were law lords within the House of Lords who sat as a committee who did that. And then for whatever reason, they wanted to imitate us. And so they created a Supreme Court. It's the same people. They created a Supreme Court. Okay. Anyway, recently there was a hubbub. I forget how many years ago. It was during COVID, but there was a hubbub because of how then British Prime Minister Boris Johnson got Queen Elizabeth, then, the late Queen Elizabeth II, to prorogue Parliament. Okay. And someone had challenged that, and the courts ruled that the proroguing shouldn't have happened. Parliament dealt with that. Okay. Subsequently, they passed a statute affirming that that proroguing was fine.
Proroguing was fine.
Okay.
Yeah.
I love that. They're like, no, you were wrong. Here you go. Here's the law. You were wrong. Now enforce this law that says that this was fine. They can basically change the law at any time. So the protections that you alluded to in the beginning, that we have in this country, the protections from government overreach don't exist there the same way. And so when Parliament is voting the way you want, great. And when they're not, you have a problem. Okay. Next example, Germany. Okay. Germany has a very, very federal system. Okay. They have these entities called Länder, I believe is the word in German in plural. Okay, they're just states. Okay, so like Nordrhein-Westphalia is one, Niedersachsen is one, Brandenburg is one. Okay, these are all states. Okay, and so they have a federal structure, federal parliament, but they have these states, and these states have authority. But the degree to which they have authority is nothing like our system. And our system pre-Civil War, certainly not even close. But I would even argue post-Civil War. It's not the same. And the relative size and comparison between Germany, which would basically fit inside of Texas and leave space left over, versus the United States of America, that includes far more than just Texas. Arguably that helps support the rationale for that, but not really, because it was that way in the beginning, as you can see from these amendments. Okay. There were men as like the Virginian Patrick Henry, to whom you referred, who were very much about states' rights, and were very much about not creating a new centralizing entity that would just, with its authority and then eventually the money that would flow because of that, begin to exert some kind of centrifugal force and just suck everything into it like a swamp. Maybe. Sound familiar?
Yeah. Okay, so that's a lot of history there, but I mean, that's why I bring Dorollo on, because he knows all this history, and he drinks directly from his bottle of Pellegrino. There, you can't see that on the audio, but it's like a 40.
Great stuff.
He doesn't have it in a paper bag though.
Oh, it's a 25.3.
Oh, okay, it's a 25.3.
So,
all right. Okay, all right.
Better
Still
for
not
the environment. It's glass. Better for the
Okay.
environment till someone's trying to smash you over the head with it. And then it's like, give me that plastic bottle, I'd be fine.
All right, so
Yeah.
there's a lot to unpack there. And I've been taking
Mhm.
several notes as you've been talking. So I want to wind back a little bit and explore a couple of things. So commas are important in the law. Commas are important in contracts. Commas and the placement of commas is incredibly important. We found this out in collectively in the United States in the 1990s with Bill Clinton's parsing of language around what the definition of is, which is my favorite sort of public example that even normal people could understand, because most normal people get really, really frustrated with how legal scholars leverage commas. And the reason why normal people get frustrated is because there's certain things normal people want to do or don't want to do, and a small thing, stops them from doing that. It kind of reminds me in a sort of a biblical way about jots and tittles in the law.
Mm-hmm.
Commas are important in the law. And to the point of the 10th Amendment, just to sort of reiterate where the comma is, the power is not delegated to the United States by the Constitution, comma, nor prohibited to it by the states, comma, are reserved to the states respectively, comma, or to the people. There are 4 commas in there. Or no, I'm sorry, 3 commas in there. 1, 2, 3. And those commas act as delineators for what we're actually talking about here, which is sort of where Dorollo was going. Now, the commas lead to, those 3 commas lead to this conception of federalism, which is the idea that there are all these, well, I'm going to give my idea of federalism, and then Dorollo can correct me. It's this idea that there are all these smaller governments that counterbalance, to his point about centrifugal force, right? To your point about centrifugal force, that counterbalance or act as a balance against the centrifugal force pieces. And when you read both the Federalist Papers, which were written by Hamilton, Madison, and John Jay, in defense of the Constitution, they asserted that you needed no counterbalance in order to protect the people, because the counterbalance was going to be there basically in the character of the individuals who are going to be elected or placed into these positions. The anti-federalists had a much more, I think, nuanced view of human behavior, where they understood that we just got out of tyranny 3 minutes ago, and you're telling me that tyranny will never arise again. Are you insane? and then that was the crux of their disagreement, particularly with Alexander Hamilton. Hamilton completely threw away or completely disregarded the anti-federalist positions, because he believed that the fundamental nature of the documents that the framers had created would be enough to bind people together. And of course, the Federalists pushed back on that, and said, no, that's not what's going to be happening here, particularly Brutus, a couple of other folks who were writing in the anti-federalist camp there. Most people these days do not understand federalism, and they do not understand why it is important. And yet, with every election cycle in our country, going back, I think now 30 years, every state rediscovers that it has rights when the opposing party is in the White House. How is it that normal people don't understand federalism,
Very well.
but these venal governors like Gavin Newsom or Gretchen Whitmer, or on the other side, what's his name down in Florida, DeSantis, all of a sudden, when an opposing member of the political party is in the White House or in the Congress, they discover that, oh my gosh, they have these rights. But normal people never figure this out. How's the progressive movement pulled the wool over people's eyes about federalism for so long?
Well, one of the things that can help, of course, is when you're getting your way. For example, I saw a news item recently, not something I read, just the title. It was talking about some kind of ethics issue at the Supreme Court.
Oh, yes.
And I laughed and I said, of course there's an ethical issue, because they're deciding in ways you don't like. That's why you believe there's an ethical issue. When they're deciding in ways you like, for example, upholding Roe v. Wade for 50 years or more, you don't have a problem with it. There's no ethical scandal. You know, murdering babies, perfectly fine. No ethical scandal. Oh, but you decide, hey, wait a minute. I can't read in the text of the Constitution that this right exists. So maybe it's not a federal right, which is to say it may be a state right, which is where I'm going to go with this part of the conversation. But yes, it is fascinating that we rediscover with each generation new rights and new powers. Or that, you know, the elected officials bored one day with apparently not doing their jobs very well, many of us would say, discover new powers and then go on an adventure, you know, seeking to further malign the lives of their neighbors, right? One of the things that I find profound from my perspective as a lawyer, constitutional or otherwise, but certainly constitutionally, is there are certain provisions about which there were no major cases or controversies for years or decades or sometimes a century or longer, and then all of a sudden a case crops up. And one of the things that, you know, the judges will point out is, well, this law has been on the books since 1789, 1791, 1790, whatever. It's still valid. So then why was it never an issue or never used? Now, I'm not saying it's invalid because of that. I'm just trying to emphasize that life can go on very well in America. And in fact, America can even be at loggerheads and literally fighting a civil war. And certain provisions of law that have been on the books for several decades just don't seem important. And then a century later, all of a sudden, bang, here's a case dealing with it. And it's like, oh, okay, well, this is odd. And so one of the two cases dealing with the Ninth Amendment that is quite famous, okay, and quite famous because it's on the road to Roe.
Okay.
Is Griswold v. Connecticut.
Yes.
Okay, Griswold v. Connecticut from 1965 was a decision that I believe Mr. Justice, they're all male at the time, Mr. Justice William O. Douglas, who was a real liberal, and one of my favorite liberals ever on that court, a real liberal, I am here, okay, to keep the government off the backs of the people, okay? He was a Westerner, and that's the part of the, you know, our country that I've adopted, where we are and where we are on purpose because of what we value. This man was from out here and looked very critically at uses of government power to mess with people's lives. So in this case, the state of Connecticut was messing with married people's rights to buy contraception. The state, with its authority, was saying, hey, we can do this. And what Mr. Justice William O. Douglas decided was, no, you can't, because the 14th Amendment, which incorporates all this other stuff, okay, apparently under the 4th Amendment, that this was offensive. Well, there are two other opinions, at least, one a concurrence by Justice Goldberg, whom you almost never hear about ever, and then another, a dissent by Justice Potter Stewart, who you do hear about. Anyway, each of them addressed the circumstances with respect to the Ninth Amendment. And this is what Justice Goldberg, who concurred, said. The language of and the history of the Ninth Amendment reveal that the framers of the Constitution believed that there are additional fundamental rights, protected from government infringement, which exist alongside those fundamental rights specifically mentioned in the first 8 constitutional amendments. And there's an ellipsis. It was proffered to quiet expressed fears, think of Patrick Henry, that a bill of specifically enumerated rights could not be sufficiently broad to cover all essential rights, and that the specific mention of certain rights would be interpreted as a denial that others were protected, period. The Ninth Amendment of the another ellipsis. Ninth Amendment of the Constitution may be regarded by some as a recent discovery. This is what we were talking about, right? And may be forgotten by others, but since 1791, it has been a basic part of the Constitution, which we are sworn to uphold, period. To hold that a right so basic and fundamental and so deep-rooted in our society as the right of privacy in marriage may be infringed because that right is not guaranteed in so many words by the first 8 amendments to the Constitution is to ignore the Ninth Amendment, and to give it no effect whatsoever, period. Now, one of the things I want to point out is a point of grammar. That last sentence, there was only one comma. And so it rolls and builds, but it's one idea. And so I like that. It's beautifully written. Now, Mr. Justice Potter Stewart disagreed. He did not see either the Ninth or the 10th Amendment that way because that's what he said. Quote, in the middle of a sentence, to say that the Ninth Amendment has anything to do with this case. Okay. So the right of married people to say, state of Connecticut, you're infringing my rights by telling me I can't buy condoms. Okay.
Right.
I'm married. I can't buy condoms. Okay. Quote, to say that the Ninth Amendment has anything to do with this case is to turn somersaults with history, period. The Ninth Amendment, comma, like its companion, comma, the 10th ellipsis, was framed by James Madison and adopted by the states simply to make clear that the adoption of the Bill of Rights did not alter the plan that the federal government was to be a government of express and limited powers, comma, and that all rights and powers not delegated to it were retained by the people and the individual states, period, close quote. The reason that matters here is in Justice Stewart's mind, federalism meant that the federal government's authority was limited. That authority included the judiciary, and therefore the judiciary's ability to say that the state of Connecticut was wrong by passing that statute was limited.
Yeah.
And here, not applicable. Okay, so that's the irony of it, right?
Mm-hmm.
This is about federalism. Federalism means we don't have jurisdiction. It means the state of Connecticut can do what it wants in certain ways, and we can't say anything about that. Okay, and it's interesting because the tension between those two opinions is patent, right? The tension is there. Do we believe that states can dictate to married couples about sex? Well, my definition of a free government, okay? I know I've said this in public before, somewhere, because I run for office, but basically my definition of a free government, okay, there's a few. One of them is that in a free government, in a free society, one of the things that the government is not doing is talking to consenting adults about sex. It's not doing it. You have other things to do. Go catch drug dealers. Why do you care if I buy this product in a store? I'm an adult. Go mind your own business, government. This is one of my conceptions of a free society, of a free government, okay? Free government is not telling adults certain things, okay? I left an unfree state, New York, to come to a free state, Arizona. I left a state that will tell you, it will tell you who can drink. It will tell you where you can get the drink. It can tell you when during the week you can buy a beer. It will tell you when during the day it's appropriate to buy a beer.
Yes,
I came to a state where I can get a beer or liquor in the grocery store, like it's totally normal. Like I'm an adult and thus can decide, hey, it's too early in the morning, or I don't want to drink that at all. I get to choose in this state of Arizona because Arizona is free. And they treat me like an adult, not like a child who needs to be told, sorry, you can't sell this until 12 noon because I don't care.
Okay, but I can hear.
I don't care.
I can hear all of my progressive listeners screaming because you mentioned sex. I can hear them screaming about the 1964 Civil Rights Act. And I can hear them screaming about how the 64 Civil Rights Act prohibits discrimination on the basis of race, color, religion, sex, or national origin. And that is, in effect, binds association. And thus the Supreme Court should have something to say constitutionally about association. And because they have something to say about association, yes, it's cute you brought up Connecticut v. Griswold from what, the 1950s?
65.
65, okay, 1965. But Oberfell v. Hodges, which legalized gay marriage, directly contradicts what you are saying. And they would say that an originalist conservative reading, because this is what they said with the overturning of Roe v. Wade, an originalist conservative reading would put gay people back in chains. Close quote. I am not saying that that's an argument that I buy. I am merely saying that that is the argument out there because of Congress passing the Civil Rights Act of 1964, which has warped how we think of both the Ninth and the 10th Amendment. We term federalism because what the Congress in essence did was it opened up the door through the Civil Rights Act of 64 It opened up the door with Title I, Title II, Title III, the desegregation of public property, which means I can't, invite somebody into my house who I don't want, or discriminate against somebody else who I don't. That actually what do you call it, undergirds a lot of real
But
estate.
your house is not public property. So
Well,
the key distinction for me,
it is if I take an FHA loan to fund that property.
so, but the real issue, the way I see it, the real distinction is between commerce and between non-commercial activity. And so a hotel is not somebody's house, okay?
Mhm.
Sorry, I don't know who's trying to call me at this time and messing with what I'm doing. Thank you, whoever that was calling from New Jersey. Anyway,
Speaking of an unfree state.
the distinction in my mind, and not just in my mind, the
Yeah.
distinction, if I'm not mistaken, in terms of how the statute is written, it's about commercial activity, because that would mean that Congress can regulate it, okay? The Commerce Clause, and commercial activity between the states. And of course, we're in a time frame where there's little commercial activity that doesn't cross state lines, okay?
Correct.
Backing up 70 years, there's certain commerce, okay?
Mhm.
And let's make it really simple. Farm to table. You have a farm to table hotel, okay? All of the food, all of the materials to construct it, okay? The utility, the electricity, all of that is coming from just within Georgia, okay? Well, are your customers coming from only within Georgia, or is this basically still going to be commercial activity? And if commercial activity, then I understand why the statute applies to prevent obnoxious, offensive, and evil behavior. Okay, it doesn't prevent that type of behavior in a private setting. It doesn't prevent someone from creating a country club and saying everyone who belongs to this club is going to be black, and that's it. That's it. Otherwise, we don't want you. It's our land. This is what we're doing. Okay, you may have the right to do that, but it's still obnoxious, offensive, and evil behavior. And so part of the duty of government itself, because it's to do justice and protect people, that's why governments exist. There's tension whenever that government is limited and whenever that limitation is happening for the government over a free society, because a free society, again, literally, my issue isn't my issue. Back to sex. My issue is the government having an opinion on it. Okay.
Right. Yeah.
Rather than saying I have other things to do, which is another way of saying I have to trust my fellow citizens. That's what they are.
Bingo.
Okay. You're not, His Majesty King Charles III. I saw an article saying, well, are these people going to vote? And I'm like, do you not understand what they are? Do you not understand that he's not a citizen, that he's not a subject of himself or subject to the crown on his head, that he's the one who wears the crown, and thus he has a different constitutional status? Here's another thing that people don't often mention. I'm highly sympathetic to Her Royal Highness the Princess of Wales and what she's going through. Is horrible. God heal her in Jesus' name. It's awful. Okay. When people say, hey, we want to know what's going on with her health, we have a right to know what's going on with her health. There's some part of me that says, no, you don't. And then there's another part of me that says, wait a minute, do you understand? Under the British Constitution, there is one woman on earth who can literally birth heirs to the throne, who can birth people in direct line to sit with that crown that King Charles III has right now. One woman can do that. And so constitutionally, there's actually an angle that would explain why somebody might, in quotation marks, you can't see me do the air quotes, might have a right to know. Okay? Now, there's a whole better way of behaving. Just be a decent human being. Pray for them and move on. Like, do you not trust these people? If you don't trust these people, you need to do some other reform ASAP.
Okay, so that is the challenge, and this is what I wanted to backdoor into, which is why talking about federalism was important before we backdoor into the administrative state. The reason the administrative state, the titular fourth branch of government, exists in the United States, the reason it has developed over the course of time since the passing of talk about the Constitution, since the passing of
it's the New Deal.
Article 16, actually, The Congress shall have power to lay and collect taxes on incomes from whatever source derived, comma, without apportionment among the several states and without regard to any census or enumeration. That was the door that opened to allow not only money to come into the coffers of a centralized beast, which you mentioned, the anti-federalists would have had a problem with, a centrifugal force, but it's a centrifugal force now run by money, gold, in essence. Gold is coming into Caesar's pockets, and Caesar has no clue what to do with it other than to redistribute it to a bunch of other apparatchiks to buy votes and to ensure that Caesar stays in power. Okay. Then you fast forward to by the way, under Woodrow Wilson, the original progressive. Then you fast forward to another progressive named Franklin Delano Roosevelt, who infamously wanted to pack the courts, right? And created the structure of the administrative state that we have now. Well, not the structure of it. He laid the cornerstone. He laid the foundation of that through, as you already mentioned, the New Deal, right? And that has just been growing over the course of time. So you had money and administrators. And what are administrators going to do? Well, they are going to, and by the way, what administrators are going to do is explained in the Supreme Court's decision that came down in the Loper Bright Enterprises versus Raimondo case that was decided this year. And I quote directly from the holding on scotusblog.com. Okay, they co-roll directly from the holding. It says, the Administrative Procedure Act requires courts to exercise their independent judgment in deciding whether an agency has acted within its statutory authority, comma, talking about commas, and courts may not defer to an agency interpretation of the law simply because a statute is ambiguous, semicolon. Chevron versus Natural Resources Defense Council is overruled, period. What does all that mean for a normal person? What that means is, because the EPA, EPA is too easy. Name another three-letter agency. The National Defense Council, Natural Resources Defense Council. Okay. Because they don't trust that a logging company will plant enough trees. They now exist inside of an administrative or under an administrative cover because they don't trust the logging company. And so they're going to make the logging company do what it is the logging company should do because they're greedy capitalists and they won't plant enough trees. And so the Natural Resources Defense Council takes a position based on a lack of trust of their neighbor, which is where all of this comes out of in the 1930s and the 1940s. The entire New Deal existed because, well, for a couple of different reasons, but a big one was Roosevelt didn't like the way that Hoover was talking about the Great Depression. And Hoover's approach to the Great Depression was, just fix the problem yourselves. I don't see what the issue is. We will do nothing. We won't print money. We're not going to create new jobs. We're not going to do any of this. And the argument that existed at the time was, or not the argument, the reason why Hoover got thrown over was because Roosevelt was able to successfully frame Hoover as a conscienceless devil. And Roosevelt would come in as a giant savior who was going to create a New Deal. Now, the devil, of course, is always in the details. And in those details of the New Deal was, of course, the growth of administrative power, which has come down to us almost 90 years later in the form of multiple three-letter agencies that now tell you, to your point about drinking a beer or whatever, they tell you not only where you can drink a beer, but they tell you what stamps can be put on that beer, what kind of beer can be made, what kind of grain can be used in that beer. You talk about international commerce, or not necessarily national commerce. Now, national commerce is administrated by individuals who will go into the factory of the people making the beer and will shut down that factory. And by the way, will make the owner of that factory making that beer, whether it's Anheuser-Busch or some small craft brewery, they will make that owner pay a fine, or even worse, pay to have inspectors show up to deliver a fine. This is where we are
Mhm.
at now with the administrative state because of a lack of trust in my fellow Americans. And this
Yep.
is what is degrading the republic. Hello. So I'm going to do some shilling here, and hopefully this will be a pause in our riveting conversation for you. I have an offer for you. My most recent book is 12 Rules for Leaders, The Foundation of Intentional Leadership. It's available in paperback, hardcover, or as an ebook on Amazon, Barnes & Noble, Kobo, and any other place you order books. Now, in this book, I address the 12 leadership areas that I have found leaders need to be the most intentional in to be the type of leader followers actually want to follow. From establishing a foundation of leading teams through managing conflict effectively, all the way through leading teams through change, knowing what to do and why to do it can help readers, like the ones listening to this show, become better leaders. Look, reading this book and living it is like getting coaching from me directly without having to pay my full coaching rate. Head on over to leadershiptoolbox.us. That's leadershiptoolbox.us, and scroll down the homepage and click on the Buy Now button to purchase in hardcover, paperback, and Kindle format on Amazon 12 Rules for Leaders, the foundation for intentional leadership. And that's it for me. Now back to the show.
Right. Or, just an unwillingness to, trust is one thing, but there's also, just being greedy and power hungry. Power corrupts, and absolute power corrupts absolutely. So, there's also corrupt officials who don't really care about your rights,
Right.
or my rights, and just want to tell us this is how you're going to make beer. Because I like this beer, this is how you're going to make it. That's it. What are you going to do? That kind of attitude. And now it's great because now you can go to federal courts and you're going to say, well, the APA says I'm going to do this. The Administrative Procedures Act says I'm going to do this. So good luck, bud. And what was fascinating is, and it's definitely way too far in the weeds, but if you back up 200 years, the government workers could be sued in trespass for doing certain things. And so there was a disincentive for the workers to overreach because they could be sued. They could be hauled into court because their action was ultra vires, meaning it went beyond their actual legitimate authority, and it infringed somebody's rights. Now you got to pay. Of course, now we have, quasi-sovereign immunity and other doctrines that I don't necessarily like that protect government employees from having suits brought against them because their actions violate the law or go beyond their lawful authority. But yeah, that's when you were describing it, it made me think of France and also the EU, because they will tell you the label size, the this, the that, like it's all very controlled, and it creates a national economy. And here, where the Constitution was set up to protect not a national economy so much as a hybrid economy that had national aspects, national scope with certain things, but also had, at the end of the day, and at least not the end of the day, heretofore. I hope there will be other states, for the record. Okay, I hope that 50 is not the end. I think there's a problem with America. 50 is the end. Just like I know that there's been a problem with America when the frontier closed. And I'm not saying go out and kill other brown people. That's not what I'm saying.
No. We could probably get Canada on the cheap, actually, these days.
Oh, wow. Okay.
I think Western Canada would come. I think Western Canada would come right in. I don't think they'd have a problem at all. The Quebecois, they can go away. They can go do their own thing. But Western Canada, anything west of Toronto, I think they'd be okay with it. All the way up to like Yellowknife.
No, moi, je garderai les Québécois.
Yeah, well, all right. You take your French and you go walk over there.
Okay,
French fry.
Yeah. And I bet they make better beer unless Canada also overregulates brewing.
Yeah.
Which they might. I just haven't checked. But that's what it sounds like. And so protecting, these individual state economies also that allow for the robust marketplace we have. You can't, I think, name a major business worth talking about that now is a massive global corporation that didn't start as some little store in random Arkansas, for example. You know, obviously speaking of Walmart. And so
Right.
the experiment that, you know, that great American Sam Walton did, I've written about it. I wrote about it in my Trump book, but the experiment that he did in doing retail that way started in a small place, and it worked. And so you can build and test your proof of concept at larger and larger levels without immediately having to swim in an ocean. Okay, you can start swimming in a backyard pool, basically. And so how you regulate the ocean and how you regulate the pool is not the same. And here, with federalism, the entity regulating the pool is not the same entity regulating the ocean.
Well,
And so
okay.
you don't have to drown because you're learning to swim in an ocean. You can learn to
Well,
swim in a pool and then expand and
okay.
prepare yourself for the level of competition where now you're competing against anybody in the country.
Well, here's the other thing, and this is why I brought up the Civil Rights Act of 1964. I didn't bring this up by accident. I think the Civil Rights Act of 1964, the knock-on effect from that in an administrative state is that regulatory bodies will interpret that act in different ways. And those interpretations will lead to forced association between entities and people that do not want to associate with each other, or will disincentivize association between entities who should be associating with each other. Case in point, if I have and I know about this because I'm in real estate, if I have a 3,600 square foot house and I want to have a border in my house, the way currently the Civil Rights Act of 1964 is interpreted by administrative regulators, the way that act is interpreted, if I decide that I'm going to advertise that as a public accommodation, I can't discriminate against anyone. But I also can't discriminate for anyone. I have to allow everyone access to this. This is why the Airbnb model or the Verbo model works, right? Now, Airbnb almost actually ran across some problems with the Civil Rights Act of 1964, initially when it started as a business, because what is Airbnb's business? Airbnb's business fundamentally, and this is, by the way, why it's not listed as a hotelier business, it's actually listed as a technology business. Because if it's a technology business, the Civil Rights Act of 1964 is silent and the regulators go away. But if you list it as a hotel business, guess what? Regulators show up and they crush Airbnb in its cradle. If I can't decide based on free association who I want to discriminate for or against, whether it be on the basis of race, color, religion, sex, or national origin, and people who fear that they will be discriminated against are leveraging the administrative interpretation of a title act in order to stop me or to coerce me into doing something, now we've got what the founding fathers feared, which is a more sophisticated form of tyranny. Now we've actually got that. And it's tyranny based on, as C.S. Lewis would perhaps note, it's tyranny based on the worst, it's tyranny of the worst kind. It's tyranny based on good intentions. There's nothing more tyrannical than opposing good intentions.
I don't think that's the worst form of tyranny. I think the worst form of tyranny is tyranny with bad intentions.
Well,
tyranny with good intentions, I might be able to use the intentions to get them that they're fellow citizens, not their subjects, they're fellow citizens, and that, you know, enter the marketplace and compete. Compete with the ideas. Trust us and trust our judgment. If you can't politically, why do you do it economically? Why do you trust that the food that they're putting on the plate and presenting to you isn't full of poison?
Right.
You can trust them with certain things. You can trust that your tires aren't going to blow up today when you drive to the store.
Right.
Okay. Now, one of the ironies is that one of the reasons we can trust that those things will happen is because of the regulating state. And I never thought about it this way until Gary Wills. I read a book of his. Okay, it's a take on you know a book with the same title by that late great senator from Arizona, Barry Goldwater, right? The Conscience of a Conservative, right?
Okay. Yeah.
I believe that's the same name of Gary Will's book. And I read it, and it was a trip for me because going into a chapter about federal regulation, I was expecting one conclusion that I shared. Way the heck too much of it, and it needs to be cut down. And by the time I finished reading the chapter, I was persuaded, some of this regulation is actually good. And I don't mean obvious regulation that bans poisons and carcinogens. I mean the type of red tape that complicates industries. There are certain aspects to that are helpful, and they're helpful because they communicate to us values and information that reinforce our trust. For example, take the airline industry. I fly a lot. I get on a plane. Am I going to pray? Yes. Do I expect to land where the plane is supposed to go? Yes, I do. Period. Okay.
Unless it's a Boeing airplane.
No, but even so, a good example. Part of the reason for that trust is because of how they're regulated, because they will put Boeing and others through the paces so that the 757 doesn't come apart in the air. Here's one of the data points to help illustrate that. When's the last time you can think of an air accident like what I just described? A really long time in this country. A really long time. And I think that's due in part because of lots of regulation. And so is it annoying? Yes. Does it have some utility though? Yes. Do I think that in general it needs the volume and the scope needs to be curtailed and the volume needs to be reduced? Absolutely. It can be far more efficient than it currently is administered. And one of the ways of doing that is just chopping it up and removing some of it entirely. I get that. I accept that. I'm still a, limited government and small state guy. So got it. But I can now appreciate its utility because of something I read in the book by Gary Wills years ago. Okay. And I wouldn't have thought that going into it. I wouldn't have thought that it really adds much once you get beyond the basic obvious things. Like you can't put poison in these things that we're eating, or that you have to tell the truth when the nutrition label asks you for ingredients, that you're not telling us things that aren't in there or not telling us things that are. I get it. But
okay, but this is a variation.
The balance is tricky.
But this is right. That's okay. So this is where I go. Right. The balance is tricky. Okay. So this is a variation of no. I'll pick on the Department of Education. I have no idea why the Department of Education exists, because
I do.
Actually, I do know why. But if we just take what the Department of Education's actual mission is supposed to be, and then we look at the outcome and the results of what the Department of Education has actually done over the last now almost 50 years, we can see that people aren't becoming more critical thinkers, able to read the back of a cereal box and go, that's poison, I probably shouldn't eat that. Instead, what we are seeing is 50 years of people educated in the public school system that was administrated by the Department of Education all the way down to curriculum at an increasingly strident level. And actually people have less critical thinking skills. So when they look on the back of that cereal box, they don't understand even how to pronounce the ingredients that are on the back of the cereal box that might be killing them. Thus, the need for a federal regulator to come in, not to educate the people better, but instead to protect them from General Mills. What the actual hell? And by the way, that's what most normal people say. Most normal, critically thinking people look at that dichotomy and go, why is the Department of Education here then? Now, again, I know why they're there. They're there for unions. They're there to disperse funds. It's a what do you call it? A money laundering.
Two ideas.
It's a money laundering scheme for progressivism.
Control,
right,
and propaganda.
And propaganda.
That's why they're there.
Right. Not
Control
education. Right. Control and propaganda.
Certainly not education.
Right. Which is why
they be there for education.
Right.
So, yeah.
Which is why I homeschool my kids, and I'm in a state where I can homeschool my kids. And
we do the same.
The state, right? The state I'm in doesn't. doesn't even care if I have children, which is great. I love that. The state should have absolutely no opinion on that whatsoever on the educational level of my children. That's a me problem, not a you problem. All right. And by the way, if you were taking care of your kids wouldn't be dumb bunnies either. Okay. So like that's a whole other thing over there. That ability though, and I appreciate Gary Wills, or the point from the Gary Wills book that you're bringing up, but that only happens. So where I would challenge Gary is here. A first domino has to fall somewhere, because for the first 100 and almost 60 years of American society and culture, we did just fine without all these administrative agencies. Now, you can assert that more people died, infrastructure was terrible, communication wasn't there, You can assert all those things. And I may grant you some of that. But on the whole, the challenge to limited government people is this. And it is a challenge that I put to you, and then we could talk about leadership here as we turn the corner. The challenge here is to limited government folks is this. How do you pare back in practical ways the administrative leviathan? Now, me personally, I believe that the three decisions that I mentioned right at the opening, so Loper Bright versus Raimondo, EPA versus West Virginia, Corner Post Incorporated versus the Board of Governors of the Federal Reserve System, these three decisions coming out of the Supreme Court, in essence, are going to force two things to happen. Number one is going to be the pruning of the administrative state in America, which I think is a good thing, to Dorollo's point. But number two, it's also going to force Congress people, and you and I talked about this offline a little bit yesterday, but it's going to force Congress to make laws that they may actually lose elections from. There may actually be an electoral consequence to you deciding that this particular piece of legislation or this particular type of administrative statute, legislation that will be interpreted as an administrative statute will have an electoral consequence, which is as it should be. We don't need term limits. We just need you to be forced into a corner to make laws you don't like and then justify them, or laws you do like, and then justify them to the people that voted for you. And then those people will decide at the ballot box if you stay or if you go. I don't believe that there's enough of these decisions having been made yet. I think we need probably 3 to 5 more years of these decisions, including, I think, a challenge to the Civil Rights Act of 1964. I think that needs to be challenged directly. I think the Supreme Court needs to have an opinion about that, either to uphold it or to strike parts of it down. And I think the most egregious pieces of the Civil Rights Act of 64 and the Civil Rights Act of 57 are around the ways that Title IX is being interpreted, in all kinds of different fashions. So the question becomes, for limited government people, because this is the challenge that progressives will put forth to those of limited government, where do we start pruning? And of course, they always ask, what agency would you like to see go first? And of course, limited government people all say the Department of Education, because it's the easiest one, because it's propaganda.
There's a simpler solution than eliminating whole departments. And I mean, I favor eliminating whole departments, okay?
Sure.
But it doesn't seem to be politically viable. So what I would propose first would just be a wholesale across the board cut of a large enough percentage that it will make a significant dent. If they don't have money, if they only have a certain amount of money to do certain things, they're going to figure out how to prioritize what they're doing. And there's certain things they won't be able to do, those agencies, because they can't fund them, because there won't be internally under the under the agency head, the will to do certain things, because there's less money. And so, for example, a 20% cut across the board in terms of what the agencies will get people's attention. And arguably it's, quote, fairer, close quote, right? And of course, I'm being slightly strident in my use there, because I don't think it has anything to do with fairness, but it can be perceived as being, quote, fairer, close quote, because it doesn't discriminate, in quotation marks again, against certain agencies versus others. It's them. We spend too much. We're going to cut the spending by 20%. It affects every single agency across the board. So here are your totals. Boop, 20% right out. Recompute. Go ahead and do what you need to do. And then they can figure out, do we really need this program? Do we really need this? Do we really need that person down the hall who's really annoying me all the time? Like, exactly. But be careful, because that employee loses his or her job for the wrong reason, and you're going to have a lawsuit, justifiably. But anyway, would unions have a fit? Yes. But do I think that would be electorally defensible? Yes.
Okay.
If we spend too much, we don't. If we spend too much, we have to reduce what we spend. And so they might not like the amount of the reduction, but if you actually want to have a real effect, it has to be enough of a reduction. And if it is, great. You got issues paying your bills in a house. Your entertainment budget is like $2,500 a month. Yeah, cut that mess by like 80% and watch what happens.
So
and you still got Netflix or any of the other, streaming, whatever. You got them still. You don't have to spend $2,500 a month on entertainment. That's crazy.
Well, the entrepreneur and former presidential contender in the Republican Party, Vivek Ramaswamy, infamously said, when he was asked about cutting federal agencies, he said he would just go in, alphabetize everybody, and then every other letter he would just fire.
See, but that's arbitrary. It's funny, but it's arbitrary, because then depending on what letter you have, and so, if he fires every other one, we got a problem, because I don't know what A is, or B, or C, but D is defense. So if it's keep A, fire B, keep C, you're firing the Defense Department? Oh. Whereas saying to that seemingly inviolable, certainly on the right, quasi-sacred institution, which of course is a notion I reject. Not that they're not important, they are. It's just, if we're going to make this scheme work, everybody's got to do the heavy lifting, including them, right? So it's like, look, here's the cut that's going to be imposed. One of the things it can allow, and I think a very Rumsfeldian way of thinking, is now you have the impetus to do reform. Everybody needs reform. And now you have the impetus to do reform. Try to learn from the mistakes of the past. And the mistakes from the past are fighting the next war based on 3 wars ago.
Right.
And one of the ways you can stop that is to say, hey, guess what? Here's the cut imposed on your budget. Now, what are you going to fund? Now, how are you going to go about carrying out your mission when there's significantly less money? Hopefully, one of those things will be determining, well, what the heck is obsolete that we need to quit doing, because we're not going to face those threats anymore. We have a new defense agency, right? We have a new, sub-agency, the Space Force, right?
Right.
Great. So more money's going into that. Does it need to come out of somewhere else?
Right.
Probably. If it's a limited grant of money, then the answer is definitely. But anyway, yeah.
One last challenge with the administrative state, and then we'll close. And it relates to what is currently going on in the contretemps around the cognitive capabilities of our current president, Joseph Robinette Biden. One of the more disturbing ideas that has come out of our sudden discovery by people in the media and collectively on the political left in our country that this man was in cognitive decline only about 2 weeks ago, is that people on the political right in this country and people who are just normal looked at candidate Joseph Robinette Biden back in 2020, took one look at this guy and figured out through anonymous accounts on Twitter that he was in cognitive decline. Somehow, everybody who ran an anonymous account on X, or wrote on a Substack, or wrote in a blog, or wrote in a newsletter that was read by 3 people, knew that this guy was in cognitive decline. And yet the media, the titular fifth estate of our country, the administrative bureaucracy, has been working just fine, even under the leadership of a gentleman and I don't think he's leading, but that's neither here nor there. The leadership of a gentleman who does not know where he is on any given day, and increasingly does not know where he is in any given moment. Now, people have talked a lot about nuclear codes. There was a lot of that conversation underneath the last president, your friend and mine, Donald J. Trump, and the lack of being able to trust that gentleman with the nuclear codes. But say what you will about Donald Trump, he at least knew where the hell he was all of the time for 4 years. An administrative bureaucracy, an administrative state that has grown so large that the executive is even dwarfed now, is a problem. And I know the CIA believes they run things, and the apparatchiks at the State Department believe they run things, and the folks at the Pentagon and the spooks buried underneath the Pentagon believe they run things. But the fact of the matter is, those are unelected positions. Those are unelected bureaucrats who do not face any consequence for their mistakes, and nor, quite frankly, get any claps for their successes. So the knife cuts both ways. In looking at Biden's cognitive decline, and in looking at this discussion we've been having for the last hour or so around the administrative state, what does it say about our country and where we are at right now in our evolution, in your opinion, that such a man is allowed to continue on without being removed? And you saw the well, you didn't see the debate, but you saw the clips of the debate, and the subsequent
No, I don't think I saw any
floundering that's been going
I try
on.
to avoid entertainment in politics.
Yeah.
So I certainly don't find them an effective vehicle to learn very much at all about candidates, and certainly not in this election. Maybe in 2016, but not in 2024. It's just a circus. So first of all, he doesn't. He could be removed. He could be removed today if they wanted, right? Because there's a constitutional amendment that provides for that, right?
Yeah, the 25th Amendment.
There we go. So he could be removed. So they're allowing him to stay there. And of course, it's both parties, right? It's not just one party allowing him to stay there. But it is what it is. Well,
the administrative state seems to continue. The bureaucrats continue to bureaucrat. The president seems to have no idea where he is. The parties continue to raise donor dollars, and the average people in the country get up and go to work. And everything seems to be, for lack of a better term, working just fine. And to me, that's the most disturbing part out of all of this.
Oh, you mean that we ignore it?
Yeah, maybe not that we ignore it, but that it seems to, for all of its administrative tentacles, right? For everything, that beer company I was mentioning with the labels, or the cereal company you mentioned, right? With the regulators showing up, or fishing vessels in Maine that just decided they had enough of federal regulators showing up on their boats, right? Which is where Loper Bright came out of, right? The wheels of the bureaucratic, administrative, managerial superstate just seem to be rolling along, with all of the dysfunctions and the cross purposes decisions. And there's no body, seemingly, either in the Congress or in the executive, who is interested in not only stopping the behemoth, but in either making it work better or making it work less. It seems as though the system, such as it were, the managerial system, has opted for stasis. And I think this is frustrating to certain people who are actually paying attention, because there are real problems in the world. So for instance, in the United States. So for instance, one of the things that Joseph Biden is campaigning on is this idea that he brought infrastructure back to America, right? Except the problem is, a bridge fell into the harbor in Baltimore. the capital of, of the state that he was a senator of for 50 years before he was president. And it's going to take him about 3 years to rebuild a freaking bridge.
Mm-hmm.
And all that
Okay.
infrastructure money that was supposedly going around, I won't say not one bridge, but because of the way bridge funding works in this country and infrastructure funding works in this country, it merely goes into the coffers of, going back to the states, it goes back into their coffers, and then it is distributed in all kinds of different ways that have nothing to do with infrastructure. Because when you cut, to your point, 20% of a budget, well, we'll just hang around. This is the administrative response to that. Well, we'll just hang around until they give us money someplace else, and then we'll siphon off some of that over to here. Because those people can't go anywhere.
Yeah, and yet, a certain amount of that is salary and other overhead. So when it runs out, it runs out. If you can't keep the lights on, it's a scandal, and somebody's going to hear about it. You're going to get fired, and someone's going to be put in charge who knows this means I have to cut people. Get your resumes ready. And again, that actually would be a gain for the private sector because there are significant skills that people who work in the federal bureaucracy acquire. And not just because of access to things, because of their substantive work and what they do. And so injecting them into the private sector would strengthen the private sector. Okay.
Do you really think those people, though, have the capacity to work in the private sector, though? I doubt they do.
I think they would because they'd be forced to. And I think that most Americans have enough resilience and certainly enough problem-solving ability to recognize, hey, I got to get a job. I need to do something. Hey, that idea I've always had about a business, honey? Now I get to try it because I got the pink slip from Uncle Sam. Okay, great. Boom. It would literally create new businesses because people would bind together and create, even if it's just a consultancy, which means you're not doing anything but talking and charging people money.
Okay. Don't knock consultants there, Esquire.
it would still boost tax revenue. It would boost tax. No, I have to do other things. I actually have to write documents. I have to submit them. I have to fly across the country to show up in court and make arguments. It's just not like a consultancy. I don't talk, and here's my bill. It'd be awesome. But that, that's not what God has me doing. So there you go. Anyway, I think that that there would be gains for the private sector and gains for those individuals. I don't think it would be a complete loss or like a butchering or something where it's like, oh, you're killing the federal bureaucracy. It's going to destroy morale. No. To the extent it destroys morale, it would be because now you see the writing on the wall, meaning you're just a cog in a wheel. And sorry, the people with seniority, they're the ones who are going to stay, and it's your butt who's going out of the window. So then how much did the union benefit you then?
Right.
Anyway.
Right.
So it's interesting. So another aspect that I think is positive is, there's two. One, the bureaucracy is functioning well enough that day-to-day life is not impacted by all these issues at the top. Okay. You go to the post office, it's still functioning. You go, your Social Security check still shows up. Okay. We didn't get bombed. So the Department of Defense is doing its job. Great. So certain things are just functioning very, very well. But it also emphasizes the strength of our federalist system.
Okay.
Because our day-to-day lives aren't really regulated or administered or controlled by the federal government, but by state governments. Okay. That's why day-to-day, we don't see the impact of very much of these obvious screw-ups by the, blatant cognitive issues that are there, and it'll be interesting, down the road, the hearings, and some of this is a critical time element. But what I would be interested in watching, presidential debates don't really concern me in an election like this. It's just, to me, pretty straightforward what's going on from both sides. So that's one thing. But I did, for example, watch, if I'm not mistaken, the Surgeon General or some other doctor testify about COVID in Wuhan. That I watched. That was fascinating. Okay. And didn't watch tons. It's me. I have no attention span, but you see the point. Would I be willing to watch, committee proceedings where the minders, the handlers, the whomever are literally forced to testify in front of Congress about what is actually going on in the mind of Joseph R. Biden, our president? Yes, I would watch that because I just want to see them under the lights on the television with billions of people paying attention, explaining stuff or trying to explain their behavior and circumstances where most of us would draw different conclusions or would draw the same conclusion and do different actions. That's what I would want to see. And of course, let me not, show up with a prejudice. They could explain, the circumstances in a way that I, would find persuasive. I know that's a possibility. I think it's a very remote possibility, but it's a possibility. And so, they should be given, as it were, their day in court. Okay. That's something I would watch. To me, that's interesting. But, the 25th Amendment is there, and he could be removed. They don't want to remove him. Fine. Would it create a precedent? It would. I'm not someone generally who thinks that health reasons matter more than political reasons. Okay. It's a political office. It's a political decision, i.e., you and I, the voters, we decide. And I know, yes, we decide electors who then go and decide. That's the system. I get it. Okay. But be that as it may, it's our system. This is how it is. So we choose the electors who decide. Awesome. I prefer that to be the mechanism that removes somebody rather than something that essentially something that is of essence a back door, a closed door back room full of smoke kind of thing. Okay, where you've got Speaker of the House is from one party, President pro tempore of the Senate's from another party. They're at loggerheads, but they're in the room with smoke and who knows what else there. Maybe smoke, but whatever else, who knows? God knows, and the rest of us don't know it's there. Talking and horse trading, because that's what politicians do. I need this, you need that. So here's what we're going to decide, and here's why. And blah, 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 blah. No. How about we, the people? How about the people? The 9th and 10th Amendments are designed to keep enfranchised with actual rights enforceable in actual courts to stop actual government action from harming us. That's the whole idea. Okay. Well, that's the whole idea of one of those amendments, and it's half of the idea of the other amendment. The other half of the idea is about states. Okay. One of my frustrations in history is listening to people now, and I don't even think it's always Marxists who do this, but listening to their conceptions of the state and when states exist versus, no, it was actually a man on a chair with an orb and a crown on his head. And he was telling people to do things. This was not the state. This was a king ruling a kingdom and direct rule and personal rule. Okay, they're historical terms that describe those circumstances. So listening to people talk about, the genesis of the Mercian state, and I'm just like, stop talking about states. Okay, that notion of states is Westphalian. Okay, it didn't show up until the 17th century. Stop talking about it that way. And the reason that it frustrates me, which is another way of saying my concern, is creating a doctrine politically that supports the notion that states as a conception are always legitimate and therefore certain other actions are automatically illegitimate and unjustified is something that I fight. Okay, something that I fight. Here's a really basic example that is all over the news today: Israel and Gaza. Okay, this notion of a Palestinian state is predicated upon these historians' views about the existence of states. Okay, you have a people, therefore there must be a state. Okay, and we don't have a government, we don't have this, but there must be a state. And it's like, no, there's people. They could create a state. Okay, they could create, something else. But the notion that a state exists somehow in the ether whenever you have certain people together, or that's one thing I disagree with. Also, the idea of looking backwards to try to find a place. Oh, here's where the state originally arose.
Right.
And so therefore, 400 years later, you look at the lay of the land, but this notion of a state, and it's like, please stop. Seriously.
Well, I mean,
it's frustrating, and it's a vehicle to deprive people of their rights. That's right. What my concern is.
Right. Okay? It's a vehicle
because the state. No, you're saying it. Where's the state? I see a
Well,
guy on a throne with a crown. I don't see a state. I see his minions who are coming at me with swords. That's one thing. That's not a
right,
state. And
right.
of course, you know, the development of states is actually really important. So I'm not an anti-statist. It's
No,
just
no, no.
I want
It's
people to understand that sovereignty and the existence of a nation state aren't the same thing.
right, 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 right. It is to me, that is the full apotheosis of, no, it's not the full apotheosis. That's not what I want. That's not the term I want to use. It's the logical conclusion. It's the clearing at the end of the path of supra-nation state philosophy that comes out of the European Union, specifically comes out of feeder entities that move into the European Union, like the World Economic Forum, who fundamentally do not believe in the sovereignty of the individual. They believe in the sovereignty of governments, which is a return to, in my opinion, a thing that the Constitution and the Declaration of Independence basically put a stake in for a good 160 years, and now it's begun creeping back. It is feudalism that they are seeking to bring back. Feudalism, where the king or whoever has a crown and a scepter decides something with this group of people. And by the way, we look at this group of people as being indistinguishable in kind from any other group of people, which is why they don't care about borders. And rampant immigration is okay with them, and rampant human migration is okay with them because whatever. And these feeder ideas, combined with and it is Marxist, the Marxist idea that we will do for you because that's the whole point of the state, gets you to what you're talking about right there. And it's the Constitution and the Declaration of Independence, and quite frankly, the nation state of the United States of America, to paraphrase from Ronald Reagan, is the last best hope, the shining city on the hill that stands athwart that kind of nonsense and yells, "Stop." Thank you, William F. Buckley. And that's our role, and that's what we should be doing. And we should be doing it inside of our own country as well. All right. We got to wrap up here. Thoughts for leaders on any of this? This is a very legalistic, political, heady kind of constitutional kind of heady conversation. What do leaders take from not just the U.S. Constitution, but what can leaders take from the construction of the 9th and the 10th Amendments? And how do they apply that thinking to their families, communities, workplaces? How do we apply this thinking? What can we do with this?
There's a few things. So one, empower your subordinates, and then trust them, to do their jobs. Don't try to micromanage. The 9th and 10th Amendments help protect federalism in the United States because they recognize that there are certain things that states have the authority to do and that the federal government does not have the authority to do. They also recognize that the federal government cannot tell the state governments to do certain things. And so either you trust your subordinates to do what you're telling them to do, or you're wasting your money and your time and resources. Second, make hard decisions. Okay, so much of what we deal with in terms of an overweening bureaucracy and other deep state issues is because people won't make hard decisions, because they won't look at a set of facts and say, look, here's the situation. Like, you can love people from all over the world, that's fine, okay, but unchecked mass immigration across the globe is completely destabilizing for states. Okay, and states here, I mean a space with one government over it. That's what I mean by state in this usage. Okay, it's completely destabilizing. Okay, it's destabilizing for epidemiologial concerns, which is another way of saying diseases show up too, and you may not be prepared for them. Okay,
right.
And in other ways, okay, but it's completely destabilizing, and so obviously it needs to be regulated. And part of that regulation means deciding who comes in and who doesn't, and deciding how many people come in and how many other people don't. Like, that's part of what that means. Those aren't easy decisions to make, but those decisions should be made. They're hard calls, and they can be made without being a racist. Again, remember, one of the things I said is, look, when you do across the board cuts of a certain percentage for, quote, fairness, close quote, considerations, this may be easier to sell. In this regard, where we're not then discriminating against people based on their origins, then it actually is a fairness factor that exists, rather than when you're just looking at federal agencies. Nothing to do with fairness when it's federal agencies. They're not people, okay? They're not people with different ethnic origins. They're different agencies in the executive branch designed to do certain things.
Yep.
Anyway, so those are two things. You make the hard calls, leaders, and trust your people. Trust your people to do what you train them to do. And if they can't do it, ask first, did you train them to do it? That's one of the lessons I have running a law firm. Okay. I made an employment decision once, and she'll laugh if she ever hears this, but I made an unemployment decision once. The she in this case is a former employee and not my wife, but my wife's comments are going to be implicated in a moment. And so I made a decision and I took a certain action. I went home and I explained it to my wife, and my wife said to me effectively in one sentence with 1 or 0 commas. So you ended the employment because you didn't train her to do what you needed her to do, but you just expected her to do it anyway. And I was like, oh yeah, that's a really good point. So about 3 days later, I had to eat crow. I apologized to my former employee and effectively begged her to come back. And then, being a smart woman, she negotiated better terms. There you go.
There you go.
And then worked for me for a good amount of time. So yeah.
Mm-hmm. Yeah.
Anyway, and it's funny because now I need to call her and let her know I said that. Notice, like, oh, by the way, I just said this. Oh, okay. So, I will let you know, because otherwise you'll have to excise those comments.
Yeah. Okay.
But it's an actual lesson. The actual lesson for an alternative soundbite is, train your people to do what you need them to do. And if you see that they're having problems, you first need to ask, well, how well did I train them? That's the actual soundbite. So there we go.
There we go. All right. Well, that's it. We've rounded the corner on the U.S. Constitution, leadership, and the 10th Amendment today with my guest, Dorollo Nixon Jr. Esquire, on the Leadership Lessons from the Great Books podcast. And with that, we're out. Thank you for listening to the Leadership Lessons from the Great Books podcast today. And now that you've made it this far, you should subscribe to the audio version of this show on all the major podcast players, including Apple iTunes, Spotify, YouTube Music, and everywhere else where podcasts are available. There's also a video version of our podcast on our YouTube channel. Like and subscribe to the video version of this podcast on the Leadership Toolbox channel on YouTube. Just search for Leadership Toolbox and hit the subscribe button there on YouTube. And while you're doing that, leave a 5-star review if you like what we're doing here on Apple, Spotify, and YouTube. Just go below the player and hit 5 stars. We need those reviews to grow, and it's the easiest way to help grow this show. And tell all your friends, of course, in leadership. By the way, if you don't like what we're doing here, well, you can always listen to another leadership show. There are several other good ones out there. At least that's what I've heard. All right. Well, that's it for me.